Hi, Kim Malek from Malek and Malek. In this video, I want to talk about House Bill 81, which enacts some changes to the Ohio Revised Code, which affects some of specifically the workers' comp sections. In particular, and specifically, what I'll point out initially is it affects 4121.471, and that's basically it's reducing the time to file a VSSR application or application for award from 2 years from the date of injury to 1 year. So now, once this is enacted, these changes, which should be enacted in roughly 90 days, probably September-ish. Once that happens, if you have an injury after these changes are made, then what that'll mean is before you had 2 years to file VSSR, now you have a year to file a VSSR. So that's one thing, and there's a few other things in this House bill, but besides that, I'm going to focus primarily on the changes with 41, which they're enacting with 4123.52. So that's revised code 4123.52F actually, and and I'll just read this. So this is what it says. So if an employee is unable to work or suffer a wage loss as the direct result of impairment arising from an injury or occupational disease, the employee is entitled to receive compensation under this section, provided the employee is otherwise qualified. If an employee is not working or has suffered a wage loss as the direct result of reasons unrelated to the allowed injury or occupational disease, the employee is not eligible to receive compensation under this section. It is the intent of the General Assembly to supersede any previous judicial decision that apply to the doctrine of voluntary abandonment to a claim brought under this section. So, I guess what they're saying is, and when they say voluntary abandonment, so that was a judicially created, judicially created doctrine. It's basically like law that didn't come from the rule makers, the legislature down at the state house. The law was created by the Supreme Court. So it may have come from an appellate court, and then the case got up to the Supreme Court, and then it basically became a law. That's how laws can be created. It could come through statute, and it could come through judges creating laws through interpretation of things. So that's what happened with this voluntary abandonment thing. And so in short, what voluntary abandonment is basically if you are like not working. So let's say you're not working, and the reason why you're not working is not related to the work injury, then what voluntary abandonment had said in the various cases was that you were not entitled to compensation. So you were not entitled to for example, temporary total disability compensation. And this also comes up in permanent total disability applications as well, where people are found to have been voluntarily abandoned the workforce. Therefore, they're found not to be eligible for PTD, or PTD is not granted rather. So how this, so I could say that, and that's about as helpful as reading the statute to you. But how does that work in theory? So the idea is, let's say I get injured. I'm working at, say, Amazon warehouse, or Myers, or a nursing home, and I have, I'm picking boxes at Amazon, or Myers. I'm setting up. I'm putting produce and stuff in the produce section, and as I'm picking these items, or I'm putting these items in the produce section, I tweak my back. I file a workers' comp claim, and let's say my claim's allowed for a lower back sprain, and generally, if I would file for, if the claim is allowed, I'm not able to work, and I'm certified by a PWC doctor, and that doctor says, hey, this person is temporarily and totally disabled for this period of time for the conditions allowed in his claim, the lower back sprain. So we're having him off from January 1st to, February 15th, whatever. So from January 1st to February 15th, I'd be entitled to, or I may be entitled to workers' comp, or temporary total disability comp. So I get injured. I filed the claim's allowed, and I have certification for this lower back sprain. Therefore, I should get paid TT. So in that case, if nothing else arose, you'd get paid your temporary total disability comp. So in that case, you're involuntarily disabled. So you're involuntarily, and this, if you want to use a voluntary involuntary abandonment situation, in that situation, you have involuntarily abandoned the workforce. That is, due to no act of yours besides the fact that you had this work injury, you're not able to work. So it's entirely because of the work injury you are not able to work, and because you're not able to work and you have certification, you're entitled to comp. So the voluntary abandonment thing, basically the way it would work out is, so you have, let's say you're working at Amazon or Meijer, you have your work injury, and then you go and you're going to pick up a check or something, so maybe your claim's allowed, and this is a week or so after the injury happens. You go in and you curse at your manager for whatever reason, some wacky thing, and then they terminate you, because so you got injured, and then you had this thing where you cursed out your manager, because you did something unrelated to work injury that caused you to be terminated. You have voluntarily abandoned the workforce. Therefore, you have severed the entitlement to compensation. Therefore, you're not getting temporary total disability. So that's so that's been a thing that's brought up over and over and over again in the courts, and it's been tweaked and turned, and there's various flavors and ways that this thing has happened. So basically, by the basic wording in this statute, it says it's the intent of the General Assembly to supersede any previous judicial decisions that apply to that judicially created doctrine of voluntary abandonment, which is fine. Which is, I don't know what that means. Does that mean that all these previous decisions are, it's like wipe clean? I don't know, but I don't know if it really changes that much, because it says, within the same thing, if an employee is not working or suffered a wage loss as a direct result of reasons unrelated to the allowed injury, so that's basically voluntary abandonment, then they're not entitled to comp. So I'm not really sure. I don't really see that this is. I'm just not really sure this accomplishes much, other than you're gonna have more. You're gonna have more legal fees for defense attorneys to argue these cases in the appellate court, and then So, but the way this, it may create more problems than it solves, is the way. Besides the case, besides having to because it's basically, the way I foresee it is, it's gonna go. You're gonna have cases that go to common pleas, and it's gonna go to appellate, and then they're gonna basically reinforce the idea of involuntary abandonment without saying this voluntary abandonment, and the way that this thing has been carved and tweaked is it's and I've talked about this case, Precision Excavating, which is just not a good case to have taken up to the Supreme Court, I feel, but the way that the voluntary abandonment thing had worked in the past is that if you were injured and your doctor had certified you temporarily and totally disabled, basically the idea is, if you're certified temporarily and totally disabled, you're incapable of working. Therefore, you've already been involuntarily broken apart from the job. So you can't then voluntarily abandon the workforce. You can't do two things. You can't have voluntary, involuntary, and then voluntary. You're either one state or the other. That's kind of the way I looked at it, and that's the way that the cases used to look at it. But then the Precision Excavating came, and I've talked about this at length in another video, but essentially what the court said is, if you do something, basically what this statute says, if it's a direct result of injuries unrelated to the allowed injury, then you're not entitled to comp. And there's a bit, and they give some reasoning behind it, and some of the reasoning I kind of understand, because I suppose you could abuse that. So let's say you could almost use that certification from your doctor as almost like a shield, like, hey, I've been, certified. You can't, even though I did this thing, like I cussed out this guy. Hey, look, I got this magic certification from my doctor. I don't, So in that case, I could see why you shouldn't be entitled to comp in that case. But in that precision excavating, they talked about two. So again, before this precision excavating, if you were certified and you're unable to work, and you're certified by your doctor stating that you're unable to work, then you would have been entitled to comp. And this precision excavating said, what they said, now when a claimant removes himself from employment for reasons unrelated to the work-related injury, which again is exactly what I've read in the statute, he is no longer eligible for temporary total disability compensation. So the way I read the statute, the change of the statute, they basically codified precision excavating. I don't think that's a good thing, but because before the case law, what the case law was even if the abandonment of employment was voluntary, must be in consideration of whether the employee was still disabled at the date of the termination. So if you had cursed out your person and you're disabled at that point in time, you would have been terminated from the job, but you would still have been entitled to compensation. And that could make a huge difference for some people. And so basically, in the facts in precision excavating was the guy had gotten injured, and there's allegedly he was talking to his co-workers. This is another thing. Don't ever talk to your co-workers about your plans, what you're going to do in work, outside work, where you're going. Unless they're like your best buds, just keep your personal life to your personal life, because what's going to inevitably, what always happens is this stuff comes back to bite the injured worker. It's because everybody wants to protect their job. So when you get hurt, the supervisor will talk to your buddy, and the buddy will be like, yeah, he said he was riding horses over the week. I mean, I literally had this in one of the cases, riding horses, and that's how he injured his hand. So silly stuff like that will happen. So bottom line is, keep yourself to yourself. You could talk about things unrelated to you, politics, whatever, but as far as what you're doing, just keep it. It's terrible that you have to be this way, but keep that information to yourself. Because what happened in this case is this guy, he was telling his coworkers allegedly that he was getting ready to resign, and that he was gonna quit, and then he was also making overtures to the company, hey, I'm gonna quit because I'm gonna go move down to Florida, take care of my mom, get a job there. So what ended up happening is he got injured, and I think he quit, and then he moved to Florida. He couldn't find a job, and then he requested temporary total. And so this precision excavating, they basically said, hey, you quit. So that is, you, again, look at the statute. He quit, so that was the direct results of reasons unrelated to the injury. So if an employee is not working as the direct result of reasons unrelated to the allowed injury. So in this case, he quit his job. So he quit his job for reasons unrelated to his work injury. Then you're not allowed to receive comp. So in this case, he quit or resigned, and so if you quit or resigned or you get terminated, you're not entitled to comp. So yeah, it could be a big deal. And my concern is, in that sense, it kind of makes sense. I mean, if I don't know the details because I didn't represent this guy, but it could have been that he moved down there and he just couldn't find a job, and for reasons completely because I think the claim was his work injury was preventing him from finding a job, but it could have been he just couldn't find a job. And so, when you can't find a job, you quit, you're not entitled to unemployment. So I need money. Let's see, how am I going to get money? I'm not going to, maybe I can get Social Security, supplemental income, maybe SSD, but let's see the options. Oh, TT, let's try to get temporary total. That's what happened here, I think. It didn't work out, and then we got this really crap law. But it's voluntary abandonment no longer applies, and so this case, I don't know if it applies, but essentially it's been codified in the statute, so it doesn't matter. What my concern is beyond this situation, and the other reason. So here's the deal. So I think for a lot of people, I'm not really certain that there's going to be situations where you find yourself terminated after the fact. Sometimes you get terminated after the fact. It seems like it's more common if you're working on light duty and you do something at the job, particularly since you're in a bubble, and then you get terminated in that situation. That's where I see the risk at. But if you're off work completely and somehow, I don't really see it coming up a lot where you're going in and you're cursing the person or something happens after the fact like that. But again, light duty, I could see it, especially if you're under like a fishbowl lens. You're in the fishbowl. You're in a magnifying glass. So I could see, if somebody's gonna be picked on, it's gonna be you. And there's always, if you do get fired, you can always, there's always potential to file a retaliation lawsuit. They're firing me. It's retaliation for me filing a workers' comp claim. But it's always going to be an uphill battle with those lawsuits. So. Not to say that doesn't happen where the folks prevail, but it's not the easiest solution in the world. But so my concern is, so there's a series of case law where this is post injury conduct. This voluntary abandonment thing had been applied to. It's always not been applied to, and in the judicial decisions. That's why I'm like concerned that they're wiping the slate clean, because in the past, pre-injury conduct and contemporaneous conduct, even if that conduct was used to, you had pre-injury conduct, you had the injury, and then you got terminated after the fact for something you did before the injury. In that case, you're terminated. You may be terminated for cause, but you would still have been allowed temporary total disability comp. So, for instance, one of the cases that came up was, which was key, was Cordell, and there's another case that followed on it, but I think the Cordell case, I think the other case pretty much upheld Cordell. But Cordell, basically, the guy was smoking weed the weekend prior, or the week prior, however, if you smoke weed, you probably smoke weed every once in a while. So this guy was smoking weed every once in a while, and then he got injured, and they did a post-accident drug screen, which is pretty much what most employers have folks do in a certain industry. I don't think that's typically done for office workers, but warehouse workers, factory workers, I don't know, probably most jobs. So most jobs have a drug-free workplace policy. So if you read that drug-free workplace policy, which will be posted in your lunchroom or something, it'll say, hey, you can't do this, and if you do, you're fired. So you're fired for cause, and there's really nothing you could argue against that. And you could say, hey, I have medical marijuana. In Ohio, medical marijuana is not they don't have anything in the statute that protects people who are found with marijuana in their system. So if you go to Michigan and you get injured and they do a drug test, you're protected. In Ohio, you're not protected. So FYI, like, medical marijuana is not a shield to getting terminated for getting a dirty drug test. But so what happens is they terminate you, and then the Cordell case, the court said, hey, yeah, he's terminated, that's fine, but he's still entitled to comp, had nothing to do with his injury, so blah blah blah. And it's because for me, the reason why I think this is important is because, otherwise employers could keep dossiers of every little thing that you did incorrectly, and then once you get hurt, they can pull out and they'd be like, oh, you didn't submit your timesheet this particular day, a month ago. We're going to terminate you, therefore cool, you don't get any comp. You know what I mean? But I don't know. So that would be my concern, is they're going to tweak that so that pre-injury conduct, for whatever wacky reason, because there's logic doesn't always prevail with these laws and how this stuff works. So sometimes it's capricious, sometimes it's arbitrary. So but my fear would be they would say, hey, pre-injury conduct, for certain things it can be a bar to compensation. FYI, intoxication is one of the affirmative defenses of employers to disallow a claim completely, and there's a rebuttable presumption if you test within a certain range on various drugs. So if you're working in a factory, warehouse, or whatever, just don't do drugs. So I don't know, if you want to do drugs and work, get a job in the office, in an office somewhere. I guess you could be a lawyer. You could probably be a judge. I don't know if doctors are drug tested, but as far as I understand, lawyers, judges, hearing officers, these sorts of jobs, not drug tested. So if you want to, as long as your life doesn't spin out of control and it doesn't impair your ability to do your job, then knock yourself out. Which, is that really fair? You know, I don't know. But that's the way society works. So, but yeah, so that's pre-injury conduct with, so there's contemporaneous conduct is also, so when I say contemporaneous conduct, that means conduct that happens at the same time or around roughly the same time as the injury. And the case that is illustrative of this point is called it's called Gross 2, but I called the fried chicken case. This kid working, I don't know if it was KFC or McDonald's or one of these places, but he was told that he had to clean out a fryer, he had to change the oil or something, and there was a way to do it safely and a way that you could do it unsafely, and he had been told in the past, like, dude, stop doing it the way you're doing it, it's dangerous, you're gonna get burned, and he did it the incorrect way, and he got burned. So I think Gross 1, I think they denied his comp, and then Gross 2 was like, this is ridiculous, this is not the way we thought this was going to work. We weren't going to use the conduct that caused him, we didn't want to use the workplace rule violation that causes injury to be the thing that it's not really fair that breaks him off from getting comp. So the reason why is because one of the reasons why is workers' comp has always been they basically remove the kind of issue of negligence. So, i.e., if you do something unsafe or clumsy, or the injury is your own fault, or the injury is, the employer did something slightly negligent or unsafe, they remove that negligence thing. So we'll sometimes get hearings where folks will be like, oh, but he kept on going on this chair and we told him not to do it and he's an idiot. And well, he might be an idiot. You're guilty of an idiocy, but you got injured. It's a work injury. The claim's allowed. And that was a grand bargain. That's the whole point of the workers' comp system, because if they didn't have the workers' comp, it's basically immunity to employers. If they didn't have that, then we'd have lawsuits. Lawsuits would potentially, it would probably be harder for injured workers for the lesser serious injuries to bring their case to the court. But for more serious injuries, the employer could potentially be on the hook for millions of dollars for these various injuries, because of the type of damages that you get for a personal injury kind of situation, and that's why workers' comp. Everybody, when people want to settle their claim or they're contemplating, they're like, they think they're going to get millions, and it's like, you're not going to get millions. You're reading these things about these massive lawsuits, and those are PI things. So you can pierce the employer immunity, but it's special circumstance. So majority of the time that doesn't happen. So you're protected. You have workers' comp claim. You're refunded that way, or you're paid, or you're compensated that way. So anyway, so this kid burns himself, and they say we didn't contemplate that the workplace rule violation that gave rise to the actual injury. We're not going to use that to deny him comp. So again, he could be terminated. That's fine. He violated a workplace rule, but he's still entitled to comp. So, but again, my concern is, I don't think that's going to change, but who knows? It could. So that's, whenever they tweak these things, it's kind of like, everything's kind of in equilibrium, and it's very fragile. And when you start throwing these things like that, there's got to be a real good reason. So that's my concern with that. And also, so if you have a workers' comp claim and it's been going on forever, at some point you'll be found maximum medically improved. The next step, if your injury was serious enough and you couldn't return to work, would be to file for PTD. So they also changed section 4123.58D3, and what it says is So what it said before was the employee permanent. So this is permanent total disability. So this is the permanent total disability shall not be compensated when the reason the employee is unable to engage in sustained remunerative employment is due to any of the following reasons, whether individually or in combination. So I'm going to skip the other ones. Go to 3. The employee retired or otherwise, and this is before it changed, voluntarily abandoned the workforce for reasons unrelated to the allowed injury or occupational disease. So that actual language, voluntarily abandoned, was part of the statute. So now, the revised code, so now it's changed to the employee retired or otherwise is not working for reasons unrelated to the allowed injury or occupational disease. I'm not really sure. I mean, I guess I doubt this is going to change much, but maybe some of these cases, if you're maybe it will. I don't know. But and when they say what a lot of times when you file for PTD nowadays is you basically have to exhaust what's called you have to attempt to return to work. So you have to try vocational rehabilitation most of the time, or you have to have some kind of injury such that vocational rehabilitation wouldn't be a realistic thing. So, like you're paralyzed, obviously, you're not going to be able to go back to work. My suggestion for all those PTD hearings is when they say, hey, this person can work, they should put them to work in the BWC. It's got billions of dollars. They could put all these people, they could be greeters at the BWC building. I don't know if they could answer the phone, but, make work, BWC. So, I'm being silly, but when you read these orders from these things, it is kind of facetious. This 80-year-old or 78-year-old person, the age is not a problem in this case. Even this person's worked in blue-collar gigs for their entire life. We think they could possibly work in a sedentary type position. It's like, yeah, really? Okay. Good luck with that, dude. I mean, I'd like some of these people make that decision. I'd like them to retire from their gig and then find a completely different job in a completely different field. It's not going to happen. It's not easy. I've done it myself. It's not easy. It's just not easy. It's not easy to find a job from a new job, leaving another job, but it's even harder to find a job in a completely different field using completely different skills and physical abilities. It is not easy. So it's almost like I wish that these hearing officers, some of these folks who do deny it on those basis, they could go through some role-playing thing, realistic role-playing, where they're all of a sudden they're not aware of it, but they're terminated from their job. It's eliminated for whatever wacky reason, and they have a really hard time finding a gig, and then they realize, oh, this sucks, and then they're like, oh, this is a joke, or this was a simulation. You have your job back, but now you know how it feels like. Because it's not easy to get your job back after you lost it. I mean, you get back in the workforce. It's hard, man. So, not to say you can't just quit, stop working, but it's not. It's an uphill battle, and it's when people do get back working, and it's awesome. It's fantastic, and I wish everybody the best of luck. But my point is, it's not always possible. So, that's HB 81. There's other things in it that I'm not really germane. I'm just not interested in talking about because I'm not really sure they changed that much. But you could read that. You could just search up House Bill 81. But those are the big things. VSSR from 2 years to 1 year, which I don't really see why they did that. Like why? It was 2 years before. Is that like really that long to have these things hanging out there? What's next? Half year to file the thing? I don't get it. But and they don't. I'm just curious what the reasoning is. And then the other thing was they removed the voluntary abandonment language or implication from the statute. So I don't know what that does for things. But so if you have any questions, concerns, issues, etc., you as always. Give us a buzz, 614-444-7440, or you could email me, kip@maleklawfirm.com. As always, all these videos and everything I talk about, I don't represent you, so there's no legal relationship. If you have a legal issue, you need to get an attorney. If you want to talk about to hire us, and we'll talk about it. Otherwise, have a safe work experience, and good luck. Thank you. Bye.